Okay. Good afternoon, everyone. We are now about to start our presentation today. We're very happy to have attorney Jessica Ryan join us. She's going to tell us she's with KSN Law Firm, and she's going to share more with us about what we should do as owners to, if we are confronted with situations where we might need to interact with officials. So this is going to be really great information. I see right now that it is 12:01. So I think maybe, just to out of kindness for people who are kind of warming up their lunch so that they can get back to their desk and start watching us. I think once it starts, the clock strikes 12:03, we'll go ahead and get started. But just a little bit about me and this organization. If you are not familiar, we are Community Investment Corporation, and we are a lender. So we provide funding for people who are looking to purchase rental property, commercial rental property of 5 units or more. We're based in Chicago, but we loan across a 6 county area. So Cook, DuPage, McHenry, Will, and I always forget one, but yeah, six, yeah. um, sorry about that, but yeah, 6 counties. We're happy to work with you, and we look to partner with people who are interested in preserving and sustaining affordable housing. So we are not profit driven, we are mission driven. And that is what is important to us, stabilizing neighborhoods. What I do, my name is Erica Miles, and I am the facilitator of the Property Management Training Program. So I work with property owners and also property managers who manage as third parties to help build success and help build best practices to be successful in rental real estate property management. So let's see, we are just about that time. So I think, yeah, let me go ahead and introduce our esteemed presenter today, Jessica Ryan with KSN Law Firm. She specializes in real estate related cases. Particularly, she works with the RLTO and also evictions. And she's going to share with us again what we should do, what owners should do in cases with potential government officials visiting properties. Thank you, Attorney Ryan.
Thank you so much, Erica, for that nice introduction. Um, a little bit more background. I have been representing landlords and rental property managers for almost 25 years. I started in 2001, so that's just mind blowing too. Um, I work with the Chicagoland Apartment Association. I'm on the board of directors and legislative committee there, so I really try to stay ahead of what's coming down the pipeline and share that with clients and community landlords in our area so that everyone is prepared. Obviously, a very hot topic this year are the immigration changes, raids by ICE agents. And if that is going on in your properties, or there's a chance that one could, it's really important to be prepared as the owner of the property and understand what your rights are as the property owner and how you should handle any interactions or issues that come up with your tenants as well. So there on the screen is my contact information. The QR code takes you to my bio. The Q&A window is set up for questions. Feel free to type in questions as we go. I will try to answer as many as I can. If there are any questions that are really specific to your property or your set of circumstances, I may skip those because they're not beneficial to everyone. And I encourage you to call me or email me after and we will discuss. And if I don't get to any emails, any questions, I apologize. Please feel free to call or. All right.
Attorney Ryan, I'm not seeing your screen anymore.
Oh no. Okay, let me. As you are screen sharing. So you don't see my screen switching?
I do not. I'm wondering, is that possibly
Our
right?
sharing.
My view. Let me ask in the chat because it's possibly it's my view. Can people add to the chat? Oh, they're saying that they see it. Okay, great. Sounds good.
Something with the host. I'm sorry.
Yes.
Oh, all right. We are going to talk about immigration enforcement and rental properties and what everyone needs to know. All right. So in January, the Trump administration initiated new and escalated immigration enforcement activities. The ICE agents, that stands for Immigration and Customs Enforcement, and they are an agency under the Department of Homeland Security. So that's how ICE and DHS are related. The stated focus of their enforcement activities is to be the removal of non-citizens with criminal convictions. I have seen that expanded, and the ICE agents and Department of Homeland Security appear to have some discretion in what constitutes a criminal conviction. So even if you have vetted your tenants wonderfully and they have no criminal convictions, it does not mean a raid couldn't happen at your property, because I have seen warrants signed and raids happen for tenants who did not have any criminal convictions. So as I'm kind of explaining, there is definitely still uncertainty regarding the scope and reach of enforcement. I will say just last week, the news was reporting that the Trump administration is again going to ramp up the number of raids. And Chicago is one of the cities that they are looking at. So it's really a good time that we're having this webinar, because I think we may see an increase in the number of raids in the coming weeks or months. We were one of the first cities that experienced the extensive ICE raids at the end of January. It definitely included rental properties. We saw quite a few larger rental properties be raided, as well as small single-family rental units and single-family homes that are rented. So understanding your rights is very, very important. Today, we're going to talk about what you need to know. How much authority does ICE have to access your property? What are the type of warrants they're going to be presenting to you, as well as the subpoenas for records, and when do you have to comply with those? I'm also going to talk a little bit about best practices to prepare for an ICE raid. Some of this may tailor more to properties that have on-site staff, but if a tenant calls from your single-family rental home and says, hey, ICE agents are here, I don't know what to do, and you run over to the property, knowing exactly what to do and to be prepared for those interactions with ICE, and having these best practices tips will be really beneficial to you as well. So let's first talk about ICE's authority to access your property. They have the right to access all public areas of the property. What does that mean? So a public area of the property is any area that the public can enter. So if, it's a single family home, inside the home is not public access. That would be considered private. If you have a yard with no fence that anyone could just wander into from the sidewalk, ICE agents will probably consider that public, even though there is no invitation to the public to enter it. A locked gate or a locked fence around your entire property perimeter definitely designates that the entire property, including the yard, is private, because the public cannot access it. So if you want areas that right now the public can just walk into, and you want those areas deemed private so that you can keep ICE officers out of those areas, you may want to consider private signage. If you have a fence, but the gate doesn't lock, ICE might consider that public because they can walk right in. But if you have a private sign on that gate, it designates the area inside the gate as private, as well as any locks to keep the public out. If you have fobs in your apartment building, fob access into any area deems that area as private. So the private areas, if you have areas that are marked and designated as private, ICE officers can only access those properties if that area is explicitly covered in the warrant. So let's say, you have a community, you have an apartment building and there's a community fitness center or a pool in your apartment community, that needs a lock to get into or fob access to open the pool gates. Those areas are private. And unless the warrant says that the ICE agents can go into the pool area or into the fitness center, they cannot. The only other way that they can access a private area is if they're given consent. And this is a big one and definitely an important issue to train any staff members you have that go out to properties, and even to inform your tenants. As the owner of the building, if you do not want ICE agents to access the private areas, you can tell tenants, do not give them access. Do not say, sure, come on in, or hey, it's hot out there. Do you want to stand inside for a minute? The second there is any type of consent for them to enter the private area, they then can search the entire private area and they will expand that. If your tenant invites them into the foyer of the single family rental home because it's 98 degrees outside, they will consider that consent to search the entire home, not just that foyer area. So it's very, very important that your staff, you and your staff understand that any invitation to ICE agents into a private area is consent for them to access all private areas in your building, that property, that single family home, whatever it may be. All right, now let's talk about warrants. There are going to be two different types of warrants that you might see if ICE agents appear at your property. The first type is a judicial warrant. Judicial means judge. That warrant is signed by a judge. It could be a search warrant to search the property or an arrest warrant to arrest someone. But the big marker on this one that's going to signify that it is a judicial warrant is that it is signed by a judge. These judicial warrants are the ones that hold weight, that you need to comply with. Signed by a judge, it's judicial, you will need to comply. And we'll talk about some of the technicalities in just a minute, but the judicial one is the important one. The other type of warrant that ICE agents often show up with, and this is, I am finding about 90% of the time, they have what's called an administrative warrant. That warrant is only signed by an ICE officer or maybe NSA or DHS agent, and it is not signed by a judge. Those warrants are much more limited, and you actually do not need to comply. You can say no to those types of warrants because they aren't signed by a judge. So let's talk a little bit more in detail. The judicial warrant, judicial judge, that's how you can remember it. Always going to be signed by a judge. In order to be valid, it needs to state the correct address of the property. It has to have a deadline in which the ICE agents have to perform the raid. So it might say this warrant has to be executed by June 30th. Or it might say it has to be executed in the next 14 days. And in that case, you look at the date the judge signed it, and the ICE agents have 14 days after that to perform their search or their arrest. When the judicial warrant is for a search warrant, it will describe the place that they can search and any items they are allowed to take. They can only search those areas. So if you have an 8-unit building and it says that they have a warrant to search unit number 3, they do not have the right to search the storage lockers. They do not have a right to search the bike room. They only have the right to search inside that particular unit. So if it is proper, if it has the correct address of the property, if it has the deadline for the raid and the ICE agents are showing up within that time frame, and it specifically says what areas they can search and what items they can seize, then it is a proper judicial warrant and you should comply and allow them into those areas. If it does not, you can say no. If your property is 123 Main Street and there's a typo and there says 132 Main Street, you can say, I'm sorry, this warrant does not allow you to search my property at 123 Main Street. You have a different address on here, and you send them on their way. And we'll talk about how you do that, right? Because you're looking at 5, 6'4" men in full tactical gear. It's a little intimidating. So we will talk about that in best practices. But if the search warrant does not comply with one or more of these requirements, they're not allowed to search your property. My understanding is they can get pretty pushy. So be prepared. Knowledge is always power. Now, instead of a search warrant, if they have an arrest warrant that is signed by a judge, it's a judicial arrest warrant. It will name the person who they are allowed to arrest. If it's proper, again, they're at the correct address, it states who they have to arrest or who they are allowed to arrest, then they do have the right to arrest that person. Now note, they are only allowed to access public areas of the building without a search warrant and without consent. So if they only show up with an arrest warrant, it allows them to arrest the person named, but an arrest warrant doesn't allow them to walk all over the property to find them. They can only access public areas. So if they only have an arrest warrant and they do not have a search warrant for that tenant's unit, you can just say, I'm sorry, you have to, wait in our public lobby here and see if he walks through. I can't let you upstairs. The last thing I have noted there is treat agents as visitors and announce visitors to residents. I will say that is really discretionary. If you have a building where you have on-site staff and your normal procedure is to call up and announce a visitor to your tenant, you can do so with ICE agents. And let them know that there are ICE agents in the lobby waiting to meet them. And then it's up to the tenant. It is not your obligation to make them come down to the lobby. All right, a little example of what a judicial search warrant looks like. Yellow, the first thing we talked about is having the proper address. So that's the yellow highlight. It will say it's on the premises known as. Now here it has a separate rider that was stapled to it. That has that attachment with the address on it, but that's what you're going to be looking for. Wherever it says, here's the premises we're allowed to search, look for that address, make sure it's your address. The blue highlight is the time frame when they are supposed to be executing the warrant, meaning coming to perform on the warrant and conduct the search. So here it says, the search warrant expires on October 23rd. This is a very old one. And the date that it was signed was October 24th. So it says it cannot be more than 10 days from the date of signature. We're okay here. Let's say they show up on October 21st. They're within the deadline. they meet that. The pink, that is where you are looking for, is this a judicial warrant signed by a judge or one of those administrative warrants signed only by an agent? Here, the pink is our signature, and it says signature of judicial officer, name and title of judicial officer. It says the Honorable Leslie Wells, U.S. District Judge. We know then that this is a judicial warrant. It is signed by the judge. You should also look for any other details that limit or restrict their searches. I highlighted that in green. Here it says that they have to make a search in the daytime between 6 a.m. and 10 a.m. They show up at 11 o'clock at night to execute this warrant. You do not have to let them in, and don't think that won't happen. Maybe 3 weeks ago, I had a property manager calling my cell phone at 12:03 a.m. on a weeknight because ICE agents had shown up at the property and their overnight security guard was calling her, and everybody was freaking out. So it is not unheard of for ICE agents to show up in the middle of the night to surprise everyone. All right, just an example of an arrest warrant, and I apologize, it looks a little bit blurry. The arrest warrant, again, down at the bottom in pink, it says magistrate judge. That's how we know this is a judicial warrant. It carries the weight of the courts. It is signed by a judge. If it meets all the requirements, you need to comply. And here, the arrest warrant just has the name of the person that they are going to arrest. And so therefore, they have the right to arrest that person. Like I said, if they only show up with the arrest warrant and not a search warrant, the arrest warrant only allows them to arrest someone, not go searching through the property for that person. So they can only stay in public areas until they see that person and arrest. All right, administrative warrants. Now, these are the ones that are signed by an immigration officer. These are not judicial warrants. They are not signed by a judge. They do not carry the weight of the courts, and you actually are not required to comply. These administrative warrants generally are just seizure warrants or arrest warrants, allowing them to arrest or seize someone. They generally do not allow the agents to search anywhere. So do not accidentally give them consent because they don't have the right to search. Does not allow them to access the unit where that person lives and does not allow them to obtain information. Be very, very careful about, your maintenance person or your landscaper or somebody saying, oh yeah, I know Julie, she lives in unit 3. Don't give away any information. For an example, I had one property, they had an on-site management leasing office. ICE showed up with 5 or 6 different agents, and the door personnel made a mistake by saying, sure, come on back in the management office, and I'll find you someone to talk to. Management office was a locked area. So that would have been considered private, but now they've got the door staff giving consent for them to go into a private area. As soon as they got back there, they spread, and they each went to a different person, different desk, different office, asking questions about the person they were looking for, trying to get somebody to slip up and give information that they were not required and should not have been giving up. So they'll be tricky, they'll be pushy. This type of warrant, administrative warrant signed by an immigration officer, does not give them the right to obtain any information. This is an example of an administrative warrant. You can see it looks a little different. It is hard to see down here. I'm sorry. It says in pink, signature of INS official. And up in the corner in green, it says Immigration and Naturalization Services, my apologies. So this is a document that is issued by the INS. It is signed by an INS agent, not a judge. One of the things that we have been noting is that these administrative warrants, it's odd, but they generally refer to the person who needs to be arrested or seized as an alien. So seeing the word alien in your warrant, if you see that first, immediately look to the signature, because I'll bet any money that if it says alien, it is an administrative warrant issued by one of the agencies and only signed by an agent. It usually refers to how I underlined red, that they are subject to removal or deportation versus actually using the word arrest. So those are the different examples, and I believe, yep, I have kind of just to go over this again. It's really, really important information to know, because one of them you have to comply with and the other one you don't. So you really need to know the differences if you're at your property and ICE agents up here. So again, the judicial warrant signed by a judge. It could be a search for arrest warrant. Who issues a judicial warrant? A judicial court, a judge, the federal court judge, a state court judge or magistrate. It is a judicial officer, a judge, who is going to issue a judicial warrant. On the other hand, the administrative warrant is issued by some type of agency, a DHS agent, an ICE agent, not a judge or any court. Compliance with a judicial warrant. Is compliance required? Yes. If all of those requirements are met, it's the correct address, they're there within the correct time frame, etc. If all those requirements are met, yes, you need to comply with a judicial warrant that's signed by a judge. Is compliance required with an administrative warrant? Only to allow those agents in a public area to arrest that person. So they're not allowed to search the property. They're not allowed to get information about that tenant or go anywhere outside of the public area, just like any other person from the public who could maybe walk into your lobby. Those ICE agents can walk into your lobby and that's it if they have an administrative warrant. They do not get to go look for that person in other places of the property. They can stand there all day and see if that person wants them. That's all they're allowed to do. If they start giving you grief, telling you they have a warrant, being pushy, you know, this is not a warrant signed by a judge. Please come back with a warrant signed by a judge if you want to access any other areas of the hearing. All right. All right, so I have a question here. Any recommendations if ICE shows up and someone who is possibly undocumented is performing work on your property? What's the best practice? Can the possible undocumented person go inside your property, which is private, to deter ICE? So first and foremost, I'm going to tell you I'm not an employment attorney. My area of expertise is rental properties and the landlord-tenant relationship. So any type of employment questions, I urge you to seek the advice of an employment attorney. However, yes, if you have a tenant, a contractor, one of your own employees, anyone, when they see ICE agents, can walk into a private locked area of your property. There's nothing stopping them from doing so. I would be very, very careful in front of ICE agents where they could see you, for you to be saying, Betty Sue, I see ICE agents, I'm getting you inside. If they have a valid judicial warrant that could be interpreted as interfering with their execution, if you're trying to hide someone, you obviously don't want to hide anyone that is the subject of a warrant, no matter your personal feelings on it. So, anyone who is allowed at your property to walk into a private area can do so if there's ICE agents there or not. So if someone on your property might be undocumented and they see ICE agents, they have the right, if they have it on a normal day, they have a right at that time to walk into private property. I discourage you from rushing around and trying to hide people when ICE agents show up. You are going to get yourself in trouble. All right. Judicial subpoena versus administrative subpoena. I am here. Somehow I did not. Oh, there we go. All right. So let's talk about some best practices. Now, if you have employees, if you have a team of a few property managers, if you have any door staff, leasing agents, anything like that, who could be at your property. If you have maintenance, you may have a maintenance person who lives on site and takes care of maintenance. You then, I strongly recommend you have a written policy and you distribute that policy to anyone who works at your property and definitely anyone who's employed directly by you. The reason I want you to have a written policy is because if you have a written policy that says your employees should do X, Y, Z, and your maintenance guy goes rogue and does ABC instead of the X, Y, Z, you have a defense. You know, maybe the tenant is going to sue you because ICE agents were let into their unit when they shouldn't have been, or something like that. And it's because your maintenance person let them in. You have a written policy and you can say, look, we wrote out a policy. I told my maintenance guy about this policy. He may be liable, but we are not liable. We did everything we were supposed to do by having this written policy and training our employees on what they should and should not do with ICE. So that's why I say have a written policy. It will protect your LLC, it will protect you, it will protect the outer layers of your structure if someone goes rogue and does not follow the policies and creates liability at your property. Your written policy should say that no one should give consent to access any private areas, that no one should disclose tenant information, not even to confirm. You don't want to, when the ICE agent says, oh, Betty Sue is in unit 210, right? I can't answer your questions, officer. You don't want to, yeah, I think so. Nothing like that. No confirmation. That is disclosing tenant information and could open you to liability for disclosing or breaching privacy rights. All right. Any on-site staff members that you have. So this would include, if you have a leasing agent, if you have a door concierge, or if you have a maintenance guy who lives on site. And they are the ones then who might be meeting the ICE officers first, because they're the ones who are actually there on site during the day. The staff members should stop the ICE officers in the public area, not let them into any private area, obtain copies of whatever documentation the ICE officers bring. Will be a warrant, if a warrant, either an arrest warrant or a search warrant. Ask each officer, every single one, each officer for their name and badge number. Generally, the ICE officers just need the business card that has that information. But it's important to get all of the ICE agents' information, not just the head guy who's doing all the time. If it is determined that the warrant is proper and they have the right to conduct a search, you need to designate someone on site who is going to accompany them throughout the search. They should never be left alone to just start running through the property unattended. They very much will take advantage of that. If you have a fitness room or a pool that is normally locked and they're walking by when a tenant opens the door, they'll go right in. They will not care. So very important to accompany officers wherever they are allowed to go throughout the property. If you have a security vendor at your property, anyone who does any type of security, whether it is a night security guard, whether you have 24/7 security, whether you just have a security vendor on call, who shows up when there is an issue. Talk to your security vendor and make sure that there is a consistency in your policies, that what you are telling your staff members to do is what they're telling their security guards to do when they show up at the property. If there's any inconsistency, my experience has been that the big security companies that work with rental properties are very much on top of this and very educated and knowledgeable. So you can definitely give me a call or talk to an attorney, but most likely your security vendors' policies are going to be the way to go. And you can kind of form your policies around there. And the other thing to think about to prepare before you have a raid is, are there private areas that are not locked or not marked, but you expect them to be private? Those you should put a sign up that says private, or you should put a lock on the door, something like that, that indicates it is private to the ICE officers when they show up. All right. For training staff members, you have to not just have a written policy, but you need to go over that written policy with your staff members. You have to explain to them that they cannot be giving consent to access, and how broad and easily interpreted consent will be by the ICE officers. And they have to be very, very careful not to say something like, oh, come on back here. I've got, an office where you guys can sit down while I look over the paperwork. That could be an invitation into private office areas. So it's really important that your staff understands that. The disclosure of tenant information. This is also a big one. Like I said, it's very easy for a staff member to accidentally confirm it. So from what I have found after those first January raids is that regular on-site staff members were overwhelmingly intimidated by the ICE agents and kind of just stuttered and only like the higher up in some of the management companies and their corporate offices or their in-house legal counsel really knew how to handle it. And so in talking to those clients, one of the biggest things was, how do I empower my employees to say no when these guys are 6'5", full tactical gear? There's 7 of them. They're all saying that they have the right to do this and the right to do that. What do you say? What do I tell my employees? So I found the best thing is to actually just give them a statement that they can repeat over and over. Let them practice it. Let them memorize it. If they just have something in their head that they can just, by memory, keep saying over and over and over, it will help them. It will empower them. They don't have to think of an answer. They don't have to think how to get out of answering a question. They just keep repeating the same thing. So here is an example. It's our policy that law enforcement officers do not have consent or permission to enter non-public areas or to access our records or information without a valid warrant signed by a judge. Any type of statement like that, it does not have to be so fancy. It does not have to be so legal. Hey, we don't allow officers permission to enter non-public areas, and you can't access our records without a warrant, without a judicial warrant, without a warrant signed by a judge. I don't care if it's layman's terms, if it's slang, as long as you are saying you can't access non-public areas and you can't get our records without a warrant signed by a judge. Really, really important. Your on-site staff should also know immediately who they should be calling to review the warrant, to get the badge numbers if you want someone else to do it, to accompany agents. Maybe you have a security company on call for emergencies, and you want that security company to be the ones to accompany the ICE agents throughout your property on a search. Maybe you want to be the person to do that as the property owner. So your maintenance person, who lives on site and, does handyman work around the property, he might be the person to meet the ICE agents. He should know, okay, immediately I have to tell them, you have to stay here. This is a public area. You cannot come any further. I am going to contact the property owner who will be here soon to meet with you. They need to know who to call. And obviously, again, I keep harping on this, don't allow the ICE agents to follow the maintenance person or your on-site staff anywhere that is private. They need to know that that constitutes consent to serve all the private areas. All right, wait. Okay. Some tips. Your staff, whoever is there, door concierge, maintenance personnel, whoever it is meeting the ICE agents, needs to remain calm but firm and treat those officers with respect. In a couple of very escalated situations, ICE agents have threatened to arrest employees on site who raised their voices in saying, no, you can't get back there. The ICE officers have said, we're not going to be treated like that. We're not speaking to you anymore. We're going to search. So those were the two instances where the ICE agents used what they considered an escalation or disrespect by a staff member to either start threatening arrests of everyone or to just search because they weren't listening to anybody anymore. So remaining very calm and respectful is very important. Obviously, you don't want to get arrested. You don't want any of your staff members to get arrested. The other really important thing to know is that you should never, ever physically touch, block, or interfere with an ICE officer. Now, this goes for any officers. If you have Chicago police coming to execute a warrant, you never, ever, ever get in the way of any officer on your property. Do not touch them. Do not try and block a doorway. If they are exceeding the scope of a warrant, when I say that, I mean their warrant, let's say their warrant says that they can search unit 210. That's it. And you are walking past the fitness center and a tenant is coming out, so the door is open, and an ICE agent stops the door and says, hey, let's check in here. You should not. I feel ridiculous even saying this because it seems obvious, but you should not, push that ICE officer out of the way, block the doorway and say, you're not going in there. You can't go in there. I'm not letting you. You will get arrested. All you can say is, please do not search this area, whatever it may be. This area is not identified in the warrant. You cannot do so. I am going to note that you are searching an area you're not allowed to search. You also can record the search. They should have their body cameras on, but sometimes those are not reliable. You have the right to start recording at any point during your interaction with the officers. And it's probably a good idea to record the entire search. If they start exceeding, if you haven't been recording and they start exceeding the scope or doing anything inappropriate or what you feel is improper, you can say, I'm going to start recording this. You're exceeding the scope. You're not allowed to go in these areas. I'm going to be recording. So at any point you can start recording, but definitely if they're exceeding the scope, if you say, I have a key to unit 310, please use the key, and they say, screw you, we're not using the key, and they kick the door down. It's important to have that on video because there is a place that you can report complaints and request money for damages. So I've not seen anyone actually get money yet, but this just started 5 months ago, and we know the government works slowly. So But it's important to have a record of any improper actions by the agent. But again, it is not your job or obligation to stop them. Do not get in their way. Do not be disrespectful. I don't want, any of my clients or attendees at seminars to end up arrested or in trouble because they tried to interfere. The other really, really important issue, and this kind of goes along with the question that was asked by Jacqueline, don't give residents legal advice. One, maybe your legal advice is a little off and it could be wrong. Two, you do not want to be in the position of giving them legal advice. An ICE agent could interpret that as interfering with their execution of the warrant. So just like you should never hide someone from ICE agents, you really should not, if, ICE gets up to the unit, they have the search warrant, they arrest the person in the unit, you and your staff members should not be saying, hey, Betty Sue, you have the right to remain silent. You should not say anything to these ICE officers. You should be requesting an attorney. Don't give them advice. That is not your job. It is not your role. God forbid you gave the wrong advice and they relied on it. They could sue you. And you also should not be acting as an attorney. Not your role. So that's another really, really important. All right, let's talk last kind of best practices. I'm going through like step by step just to kind of really hammer all of this home so you feel confident and really know what to do. If ICE appears at your property, you are going to, I should probably have 1 and 2 swapped if I'm going to be honest, but these kind of happen at the same time. You are going to clearly state that you do not consent to search of any private areas without a warrant signed by a judge. You're going to ask the agents to stay in whatever public area they are in. If they walked into a private area, say this is a private area, I do not consent for you to be here, please follow me to this public area. If it is your maintenance person or on-site staff, they should know to get whatever staff is designated or you as the property owner to deal with the agents. In the same conversation, confirm what agency they're from. I will say too, ICE agents have shown up at properties with police markings on their tactical gear and it does not say ICE. So confirm what agency they're from, get all of the agents' names and badge numbers. That should be in no consent. What agency are you with? Give me your names and badge numbers in the first 30 seconds of interaction with the ICE members, with the ICE agents. Then whoever that designated staff member is. So if it's going to be your security vendor, if it's you as the property owner, the person who is educated on this issue and knows what to do should be requesting their documentation. Get a copy of it. You are absolutely allowed to have a copy of it. They should have more than 1 copy so you can keep one. If not, you have a right to go to your copier and make a copy of it. If it is a judicial warrant signed by a judge and everything is proper, then someone's going to accompany them through the search. And that person should know exactly what they are allowed to search, what's listed in the search warrant, and just be aware when to record if any of the ICE agents exceed that scope. So that's coordinating that. If it's an administrative warrant, and if you remember, those are the ones only signed by an agent, you can advise the agents that you do not consent to any search, that they can stay in the public areas, but until they have a warrant signed by a judge, they are not allowed to search anywhere else in the property. The only other type of document they might have is a subpoena for records. And it will say subpoena for records usually across the top. They might be asking for, tenants' leases, like the name of the person. They'll have the name of the person that they want to arrest or seize. And the subpoena may list documents like the lease, their account ledger, different things like that. A subpoena usually gets about 30 days to respond. I have never seen an ICE agent actually show up with a subpoena. Those are usually mailed or emailed to the property owner, and you have about 30 days to respond. So in the case that they have their search warrant, their arrest warrant, and they also have a subpoena, you can just say to the subpoena, we'll review it with our legal counsel, and if we need to comply, we'll do so within that 30 days. You don't have to comply right at that moment. You will have in the subpoena, it's usually about 30 days. Next step, if their search warrant, their judicial search warrant is valid and they're taking a tour, next step is that someone's going to accompany them on that search, remind them nicely and respectfully of the scope of the search if they try to go beyond, and take a recording or video when necessary. My number 5, I'll tell. Okay, so if a resident is arrested, ask the ICE agents where the resident is going to be detained. They will probably say, we're not telling you that. They might ignore you. They might just say no. The reason you may need to know that is if there is, non-payment of rent, if there's one tenant left in that unit who can't pay rent and you need to serve a 5-day notice, we can serve 5-day notices on arrestees who are in jail. It's a very, very simple process to serve someone in jail. So if you know where they're going to be detained, it might make that process easier if you do have to serve some type of notice or lawsuit on them. The chances that ICE is going to tell you are slim to none, but if you have that information, it might be helpful. If you have other people, your attorney, you work with shareholders, or you have other partners, a big management office, maybe you're the property owner, but you also have a professional management company. You should contact them and let them know what has happened. If you have an attorney, contact your attorney, ask them the questions, let them know what happened, send a copy of the documentation and warrants, subpoenas. If you wrote up or your maintenance person wrote up an incident report or an email that describes exactly what happened, those should go to your partners, your management company, and your attorney. Always, always in some type of summary, whether it's just an email to your attorney or you have like a formal incident report. You want to include the names and badge numbers of all of those agents, the areas that they searched, the persons that they arrested, any concerns you had, if they went outside the scope, if they damaged part of your property, and include any video that you have. Your property manager will keep those records. I know as an attorney, I keep a client's records for whether I'm no longer representing them or not. I have records, going back 25 years that are now in storage, and it might take me a month to dig them out and find them for someone. But those records would be held by the professionals and experts that you work with in case you need them down. Last, if you did have concerns, if any of your property was damaged by ICE actions, there is a place on the Department of Homeland Security and the ICE website where you can register complaints. So I think it's important to do so. I think it's important that these issues are tracked. I don't know who exactly is tracking them in the federal government right now, but it is important to have a written record at the federal level of anytime ICE agents exceed the scope, do something they're not supposed to do. Really, really important to make a record of that. And even more important, when your property is damaged, you can get it repaired and submit the complaint with the invoice, and then hold your breath and cross your fingers that you get paid by the federal government. I did not mean to laugh when I said that, but really don't hold your breath, because so far we've had 2 or 3 clients who had property damage and submitted it, and they haven't even received a response. So I don't even know if anyone is monitoring that complaint portal, but if there's a chance down the road that you could get reimbursed for damages, you need to put that in right. All right. If your tenant has been arrested, being arrested is not a breach of the lease. I have some concerns that serving them with a 10-day notice for breaching the lease because they got arrested at the property could be discrimination based on immigration status. It's unclear, it's very gray. However, if rent goes unpaid, you can definitely serve a 5-day notice. If the unit's now vacant, if they have a real tenant and they're gone, you can post it. We may be able to track them down at the detention facility. That's kind of iffy, which is why I tell you to ask the officers in case they feel like giving out that information. We could serve a 5-day notice on them there. 2 ways to take possession. One, the safest route is to go through eviction proceedings. I know right now the eviction courts are very long and very backed up. However, using abandonment, there is case law in Illinois that says if a person is deceased, hospitalized, or arrested, those situations are not abandoned because the tenant did not voluntarily abandon the unit. So if you do retake the property by abandonment, that there's belongings in the unit in Cook County in Chicago, you have to wait 32 days with no rent paid and no activity or presence of a tenant. It allows you to retake possession of the property by abandonment. Like I said, an arrest is not abandonment, but if you choose to take the risk, I strongly recommend that you store that tenant's belongings for even 3 to 6 months in case they come out. Because one, just using abandonment and not going through eviction proceedings after arrest is a wrongful eviction, and you could have to pay 3 times that tenant's damages. If you also throw away all their property, you are going to owe them the cost of all of that property, furniture, clothing, everything. So best route is evictions. I have some clients who are like, I'm not waiting 6 months for an eviction order to get this property back. I'm just going to retake it by abandonment. That is a risk. You have to understand you could get sued for wrongful eviction. But in addition to the 3 times damages, you don't also want to pay for their personal property. So at least store the personal. All right. That brings me to the end of the presentation with 2 minutes to spare. Again, here is my contact information. Feel free to reach out with any questions that you have that might be specific to your properties. Again, my firm handles evictions, property tax appeals, building code violation defense, RLTO, Cook County RTLO, discrimination, a whole slew of different types of law. We're kind of a one-stop shop for landlords and rental property managers. So please reach out if you have any issues. And it was wonderful speaking to all of you. Thank you so much for participating today.
Attorney Ryan, thank you so much for the information. That was so valuable. I don't know if you saw the applause going up, the reactions. Also, people are adding to the chat how helpful this information is. I will say for myself, everything that I learned here was fresh and new, but my 3 biggest takeaways were learning about the 2 different types of warrants. I was not aware of that. Also, when you talked about signs, having signs in on the exterior which mark areas as private, that was very helpful. And then when you mentioned having written policies, just in case any staff or employees take a different route, you have a way to protect yourself by saying this is how it should have gone. So again, thank you so much for this information. So glad you could join us. And if anyone has any questions, we invite you to please definitely follow up with Attorney Ryan. And also, CIC offers property management training. We support best practices for independent owner operators. So we welcome you to reach out to us and attend one of our trainings and get more helpful information like this. Thank you.
Thank you. Have a great day.
You too.